All right, today we're going deep. We are cracking open a U.S. government court filing to see how the sausage is really made. This document is called a motion to dismiss, and it's basically a legal playbook designed to get a lawsuit completely thrown out of court before it even gets off the ground. Let's get into it. Wow. So the government does not pull any punches here. I mean, this is the very first sentence of their legal argument. They immediately frame the entire debate as a fight to protect American jobs from decades of abuse. This one line sets a really powerful, really provocative tone for everything that follows. It's their entire justification right up front.
So what is this all about? At the end of the day, it all comes down to this number. The lawsuit is aimed squarely at Presidential Proclamation 10973, which can hit some employers with a potential $100,000 payment if they want to hire certain H-1B workers. This fee? Well, this is the flashpoint. This is the one thing that has kicked off this massive legal challenge. Now, to get this case tossed, the government has basically built what I'm calling a legal gauntlet. It's a series of arguments or barriers that the folks suing them have to defeat one by one to even have a chance. So we're going to walk through each of these barriers together. From whether they can even sue in the first place, to whether the court is even allowed to rule on this, and finally, whether the president had the power to do this to begin with.
Okay, Section 1, a proclamation under fire. Let's just get the basics down. The core conflict here is actually pretty straightforward. A presidential proclamation came down that put new restrictions on the H-1B visa program. And, well, a whole bunch of different organizations are now suing to stop it.
And you gotta see who's suing here. This isn't just one niche group. It's a really broad cross-section of the economy. You've got for-profit companies, religious groups, nonprofits, major labor unions like the UAW and SEIU, and even just one person, John Smith. This kind of diverse coalition tells you just how wide the perceived impact of this proclamation really is.
Okay, that brings us to the first major barrier the government throws up. Argument 1, no standing. This is a huge one. They're essentially looking at the plaintiffs and saying, you don't even have the right to be in this courtroom. It's a fundamental rule. Before a judge can even listen to your argument, you have to prove you have a right to be there. And that right is called Article 3 standing. You can think of it like a ticket to get into the game. If you don't have a ticket, you can't complain about the refs. To get this ticket, you have to show 3 things. 1, you've suffered a real actual injury, not just a what if. 2, that injury is either happening now or about to happen. And 3, that injury was directly caused by the actions of the person you're suing.
So the government's first line of attack is aimed right at this requirement. They argue that the plaintiffs haven't actually been hurt yet. Their whole injury, they claim, is just speculative. It's based on a long chain of ifs and maybes that might never happen. And you can see the strategy, right? If you can prove the other side doesn't even have the right to sue you, you never have to actually defend your policy.
And to make this point, the government lays out this whole domino effect. They say, look, before this fee could ever possibly apply, an employee needs a special waiver. Then their employer has to file the petition. Then that petition has to win the H-1B lottery. Then their request to change status inside the U.S. has to be denied. With so many things that have to go wrong, can you really call that injury imminent? That's their question to the court. The government also goes after the big groups, like the unions. They pull on a Supreme Court case and say, hey, you can't just sue on behalf of your members and say some of them might be hurt. You have to name names. You have to identify specific people who are facing this harm so the court can actually see if their injury is real. All right, now for the second barrier, no review. The government's argument here is pretty bold. It's basically, okay, even if you could sue, this court has no business being here. You can't tell the president what to do on this. It's a classic separation of powers argument.
The key idea here is something called consular non-reviewability. It's a legal doctrine that's been around for a long, long time. And it basically says that courts don't get to second-guess the decision of a consular officer at an embassy to give someone a visa or not. The decision of who gets to come into the country is seen as a core power of the executive branch, not the courts.
So the whole disagreement really comes down to how you frame this thing. The plaintiffs say they're challenging a big, broad policy that affects everyone, and that's something courts can review. But the government says, no, this isn't a policy. This is a presidential entry decision, an order to the people at the gate, and those kinds of decisions are not for the courts to mess with. And that leads to another one of these procedural traps. You see, you can usually only sue a government agency over something called a final agency action. The government says, well, there isn't one here. The agencies involved, they're not making any decisions. They're just robotically carrying out the president's direct order. And if that's true, there's nothing for the court to review.
Which brings us to the third and final barrier, presidential authority. You can think of this as the government's ultimate fallback plan. Their argument is, even if the plaintiffs do have standing, and even if the court can review the case, it doesn't matter because the president was acting completely within the power that Congress gave him.
The plaintiff's whole case is built on the idea that the president acted ultra vires. It's a Latin term that just means beyond the powers. They're saying the president did something he had no legal right to do. So the government's job here is to prove that he absolutely did. And here's their proof. They point directly to this federal law, Section 1182F. And just listen to this language. It lets the president suspend the entry of all aliens, or any class of aliens, anytime he thinks their entry would be detrimental to the interests of the United States. I mean, that is an incredibly broad power for Congress to hand to a president.
And to really hammer this point home, they bring out the big guns, a major Supreme Court decision, Trump v. Hawaii, which dealt with this exact law. In that case, the Supreme Court said this law exudes deference to the president. The government is basically saying, see, even the Supreme Court agrees that when it comes to this power, courts need to back off and give the president a ton of leeway. So after building this incredible 3-layer legal fortress, the government finally gets to its last page and makes its demand. This is the whole point of the document, right? To tell the judge exactly what they want. And their demand is simple. Dismiss the amended complaint with prejudice. Now, that little phrase at the end, with prejudice, is absolutely crucial. That doesn't just mean dismiss the case. It means kill the case. It prevents the plaintiffs from just fixing a few things and filing the lawsuit all over again. It is, for all intents and purposes, a legal checkmate.
So as we wrap this up, this case really leaves us with a huge fundamental question that goes way beyond just H-1B visas. It forces us to ask, in the delicate dance of our government, when the president takes action, especially on something like immigration, where does a court's power to check that action actually begin, and where does it end? That's the enormous tension at the very heart of this legal battle.